Then I had flagged prior use exception. What exactly does prior use exception mean? Very few really understand this, and in fact, as far as I know, it has not really been applied yet. If you come across a case law in which this has been applied by the courts, it will be very good if you share it back with the entire team. Now, to talk about the prior use exception. How does it sound when I say that if I have been using a patented product which is patented now, but I have been using it much more longer, much before it was even filed, even before it was patented, I have been using it for that time since then, and therefore I should be allowed to continue to use. Do you think it makes any sense under the Patent Act? Is it logical? Normally, it would not be deemed logical due to two reasons. One, novelty is one of the main criteria of patentability. And if somebody has been using an invention even before it was filed or before it was granted, it cannot logically be done. And second is to do with the fact that once a person has gotten a patent right granted to him by the patent office, then he is deemed to have the rights from the date it was first published in India. So, how does this work out? This works out due to what is known as the historical precedents that we have built into the Indian Patent Act. Many of you are aware that based on Justice Iyengar Committee report, when an newly independent India set about revamping its Patents Act, it came up with an act which said very clearly that only process patents will be granted for pharmaceuticals, medicines, chemicals, food. Product patents will not be granted. This was the law which is known as the 1970 Patents Act, which came into force in 1972. For almost 30 years, this is what happened and went on. But once we became members of the TRIPS agreement, the trade-related aspects of intellectual property rights agreement under the WTO, we had to, under Article 27, grant patents in all fields of technology, and we had to grant product as well as process patents. One of the provisions under the TRIPS agreement said that if it was a developing country, then they would get time to implement this provision. It also said that if you do not have a provision for granting product patents in all areas of technology, then you will get time. So, these two times put together gave India, a developing country at that time, 10 years in which to implement the Article 27 of the TRIPS agreement. And this meant that there were transitional arrangements made, and transitional arrangements in this case were the mailbox applications. So, for product patent applications for products were filed in India, and that was allowed under the 1999 amendments, and they were put into a mailbox to be opened only in the year 2005 for purposes of examination and grant of patent. So, Section 11A(7) has certain provisos. In all, there are 3 provisos, and they are very interesting provisos. The proviso 1 states that provided that the rights of a patentee in respect of applications made under subsection 2 of section 5 before the 1st day of January 2005 shall accrue from the date of grant of the patent, not from the date of the publication, but from the date of the grant of the patent. And section 5(2) relates to the very peculiar section that we had under the original Patents Act of 1970, which granted only process patents to drugs, pharmaceuticals, medicines and food and chemicals. The provision, the proviso to section 11(a)(7), the third proviso, is even more interesting. It says that provided also that after the patent is granted in respect of applications made under subsection 2 of section 5, the patent holder shall only be entitled to receive reasonable royalty from all such enterprises which have made significant investments and were producing and marketing the concerned product prior to the first day of January 2005, and which shall continue to manufacture the product covered by the patent on the date of grant of the patent, and no infringement proceedings shall be instituted against such enterprises. Very interesting. So, this particular proviso to section 11(a)(7) states that if I was manufacturing a drug on which a patent application had been filed under section 5(2), and I had set up factories to manufacture this before the first day of January 2005, then even after the patent is granted to the rightful patent owner, he cannot bring a case of infringement against me. Instead, I would have to pay him reasonable royalties, and I can continue with the right to work that particular invention. The last one is exhaustion of patent rights, and this is enshrined in section 107(a)(b). This was also introduced in the Patents Amendment Act of 2002, and it very clearly said that if you import patented product and any person imports it from a person who is duly authorized under the law to produce and sell or distribute the product, it shall not be considered as an infringement of patent right. Why does it say so? Because there is something known as the principle, the doctrine of exhaustion, or the first sale doctrine. The rationale is that when a patent holder has already reaped the benefits conferred by the patent, then he has finished his rights in that particular patent, and he cannot extend that right indefinitely to further sale. Thank you.